Okay, I think we have one counsel, and now we have the second counsel. Okay, fine. Attorney Serafin, you represent the appellant in this case?
I do, Your Honor.
Could you help me out here? I want to make sure I pronounced the surname properly. Is it Kleiman?
Kleiman, Your Honor.
Thank you. And did you wish to reserve any time for rebuttal?
Yes, I'd like to reserve 5 minutes, please.
Okay. Thank you. You may proceed.
Good morning, and may it please the court. My name is Stephanie Serafin from Corser, Walsh, Vargas, and Serafin. And along with trial counsel Stephen Deutsch and Bo Blumberg, I represent the appellant, plaintiff below, Jan Kleiman. This court should reverse summary judgment. There are genuine issues of material fact as to Publix's actual notice of the vomit on the back speedway and its failure to warn. The trial judge erroneously stepped into the role of a juror and resolved fact disputes solely based on its interpretation of a surveillance video. This was error. There are 2 primary questions on which there are disputed fact issues: actual notice and failure to warn or act reasonably after having received actual notice. The first disputed fact
question for you, Ms. Serafin, about
Yes,
actual notice and your argument in the briefs regarding Publix's pick up the spill policy. What does Mr. Hancock's alleged failure to follow that policy with regard to spot 1, because he left to go get the trash can, have to do with whether or not Publix had actual knowledge of the vomit in spot 1?
Sure, Your Honor, and I want to answer in 2 ways. First of all, there's a disputed fact issue as to whether there is a spot 1 and a spot 2, and whether those are 2 separate spots, how far away they are from each other. And the policy is put in place so that an employee stays with a spill, and Mr. Hancock knew there was a hazard on the floor. And once the employee stays there, the employee is in a position to do something to prevent customers or employees from falling, including verbally giving warnings of a hazard in the area, or just being present in an area to alert customers of an issue. And going back to the first response, that's exactly why this is a case that needs to go to a jury. The trial judge made a fact finding in this summary judgment order that there was a spot 1 and a spot 2. That wasn't that may have been the testimony of some of the witnesses, but it certainly wasn't undisputed. We have Publix's corporate representative, Christy Allgood, who Publix designated to speak on the issue of the condition of the area in the 15 minutes leading up to the fall, who testified that the vomit was in a trail. Ms. Kleiman also testified that she looked after she fell and saw the vomit in a trail. And the video shows the little boy walking down the back speedway with his hands cupped under his mouth, vomiting. So there is certainly evidence in the record this was not just a single spot, that it was a trail. And we see.
Well, so the question though is what did Publix have actual knowledge in the 39 seconds between when the child started to vomit and when Ms. Kleiman fell?
Publix had actual knowledge that there was a transitory substance, vomit, on the back speedway. And Mr. Hancock admitted that. He says he knew, he looked out of the corner of his eye. He saw a child, in his words, in the process of throwing up. So he knew a child walking from that direction in the process of throwing up had put vomit on the floor. Then you see him in the video, and this is why the video is important, and in fact doesn't resolve these fact questions, it creates them. You see him going back and forth. He's going back and forth between a cart and a refrigerated section of the speedway, at times looking down the speedway, both before and after the incident, in the direction from where the child came. He knew there was a hazard. What did he do? He left. And
he knew that there was a hazard at a particular point, but knowing that there was knowing that there was a trail of vomit, his knowing that there was vomit where Ms. Kleiman fell, that's pure speculation, isn't it? I mean, doesn't that require some inference stacking?
It doesn't require any inference stacking. It's just a viewing of the evidence in the light most favorable to the plaintiff. It's viewing the video, watching Mr. Hancock's actions, watching him at times, both before and after, looking that direction, and putting that evidence and his admission that he knew there was vomit, at least in one spot, up against his testimony that he didn't know how far down it went. And that's a fact issue for the jury. It doesn't require an inference.
Let me ask you a question about the law. We have a couple of cases that are fairly similar here. Tell me why this case is really different than, I think it's our case in Heiser, where 90 seconds after a mayonnaise jar fell and splattered mayonnaise all over the floor was not enough time to charge the defendant with actual notice. I realize it was the case predated the statute that we have on the books now, but the analysis is the same in terms of actual notice and the time and what's reasonable for a plaintiff to establish here. So to talk to me about that, and while you're at it, I'd also like you to address the part of the Dolgencorp case, the holding not on duty to warn, but on actual notice, where again, liquid detergent's on the floor for 51 seconds, and that was insufficient to charge the defendant with actual notice for purposes of the first part of the duty and the statutory inquiry.
Sure. I'll address Heiser first. That was the mayonnaise jar case. And that case is factually different than this case because of how the employee received actual notice. And that is a critical point. That's a point that's made in Perez-Brito by the 11th Circuit. In that case, the employee was on a different aisle, an adjacent aisle, heard a mayonnaise jar fall, but he testified that he did everything he could. He went immediately to the location where he heard the fall, but it took him 90 seconds to get there.
Well, can't we give Mr. Hancock credit for, not having actual split second, right this instant, being able to recognize all the places vomit might have been? The vomit that was closest and in front of him is what he immediately tended to. I'm not sure that your distinction really makes a lot of a difference here in terms of what the defendant's employee could or should have done in the time that they had.
Well, let me respond.
Talk to me about the detergent on the floor in Dolgencorp for purposes of actual notice in 51 seconds.
Sure. So in Dolgencorp, the time frame for actual notice that you're referring to, the 51 seconds, had to do with the defendant's ability to rectify the situation. That's a slightly different question. It's actually a different question than a failure to warn, because in the cases show that the timing does come in when you're arguing that the defendant should have cleaned up the situation.
Well, that's what I'm asking you, and that's why I wanted to carve out the duty to warn for purposes of discussing Dolgencorp. Here, what could Hancock have done in the 39 seconds between when he appreciated the situation, attacked the one that he saw, and by then Ms. Kleiman was down?
Well, what he should have done, number one, is follow Publix's policy of staying with the vomit. And then what he could have done is to warn, to call out, to say something, to notify. There's evidence in the record that there was
so he should stand nearby at the end of the speedway and yell, "Child throwing up"?
Well, he could say,
while the customers walk up and down?
He could say, "Watch out, there's a hazard." There is a reason why the law recognizes a duty to warn. And sometimes that warning is verbal. And in this case, maybe that's what it should have been. But the evidence shows, and I want to clarify the timeline a little bit, because Publix has convinced the trial court to make another fact finding that there were only 8 seconds of time frame. But if you watch the video in light most favorable to the plaintiff, as it must be, there were at least 14 seconds between the time that the child came near Mr. Hancock and when Ms. Kleiman fell. 14 seconds, if you watch the video, is not a short amount of time in terms of this area where we were, where it's all in the same sight line, it's all in the same area, to have done something other than leave, violating the policy.
He didn't leave, though. He turned and grabbed a trash can to cover the immediate hazard that he spotted.
He did that, but that's why the policy is important, because a jury needs to determine whether that was reasonable. We have evidence that Publix put the policy in place to stay with the spill exactly for this reason. They are supposed to notify another employee to get cleaning supplies or to get a garbage can if that's what he chose to do, instead of leaving the spill. And that's exactly what we say he did wrong here, what our expert affidavit says that he did wrong here. He had no opportunity.
Why wouldn't that only be significant if Ms. Kleiman slipped in the spot where, right in front of the bathrooms where Mr. Hancock noticed the boy throwing up?
Because again, it is not undisputed that that's the only area Mr. Hancock was aware of. That's what he testified to, but there's nothing in the law that I'm aware of that requires a defendant to admit to actual notice for there to be a jury question.
But what is the evidence suggesting that he did know, other than, what is the evidence suggesting the conflict?
Sure.
That after the fact that it was determined that there was actually a trail?
Well, if the trail was there after the fact, I think it's reasonable to assume that's how it was before the fall also. And we see him.
How is that reasonable? I mean, we've seen the fall. She slides under the cart, which then rolls some distance down the speedway. For all we know, the cart created the trail.
Well, there's no evidence, there's no testimony that the cart created the trail. But
what is the evidence or the testimony that he knew that it was there? If you're just saying when we looked afterward, it shows that it was there, that's fine. We all acknowledge it was there. But what is the evidence that creates a reasonable question of fact as to whether he knew that it was in that spot?
Sure.
Okay.
So watching the video, you see the child begins to vomit at a certain point on the back speedway. The child walks with the woman, cupping his hands under his mouth down the entire back speedway.
And are we watching that from Mr. Hancock's perspective?
There are two perspectives. The cameras are located in two separate areas. There's camera 4 and camera 6. One of them shows Mr. Hancock's perspective, so to speak, and one shows more of the child and the woman. But this was within sight line. So you see the child walking towards him, cupping his hands under his mouth, vomiting.
And the evidence establishes he was looking in that direction as the child was walking toward him?
Well, the video shows him at times looking in that direction, then looking back at the refrigerated case. He was stocking a cheese case. He was going back and forth between a cart in the middle of the aisle and the cheese case. He's walking back and forth during that time. You can see what appears to be his head turning down that way. Then the child and the woman come into the bathroom. He admits at that point, he saw the child out of the corner of his eye and knew he was in the process. He says in the process of throwing up. Then what he does is he looks, immediately after that, he looks down the speedway exactly in the direction from where the child had come. He pauses for a matter of seconds. Then he turns 90 degrees. And at that point is when he decides to leave to get the garbage can, come back, and Ms. Kleiman has fallen at that point. So that evidence creates a fact issue. The jury should have the opportunity to decide whether that is enough knowledge to establish Publix's liability in this case. Publix's employee knew there was a hazard on the floor. He acted negligently. He violated Publix's policy. He left the area, he came back, and Ms. Kleiman had fallen. And it's our position the trial judge should not have made fact findings in this order, should have allowed this case to go to a jury. And I don't know where I am in my time. I'd like to answer any other questions.
You're at 13 and a half.
Okay. I'd like to, unless the court has any more questions right now.
I do have a question. I want to make sure I understand your argument appropriately. You're suggesting that Mr. Hancock from Publix could see the vomit at its location, which suggests that this is a visible condition. Is that correct?
Yes.
That would mean by the use of your ordinary senses, as he did, his eyes, that the plaintiff should have seen it as well, right?
Well, the plaintiff was coming
there's
around.
Two duties here. The first one is a duty to warn, and there's a duty to maintain. And on the first one, my understanding is some of the case law says if it's an open condition, open and notorious by the use of your senses, then the plaintiff is charged with that, and that would tend to obviate the duty to warn, because you could have seen it. That leaves us with the second duty. So is a plaintiff arguing both duties? And if that's the case, as the third district wrote in Dominguez versus Publix, a proprietor has the right to assume the invitee will perceive that which would be obvious to him upon the ordinary use of his own senses. And if Mr. Hancock could see it by the ordinary use of his senses a distance away, would not the plaintiff be able to see it the same, which I think kind of interrelates with Judge Yoakum's argument about, hey, what facts do we have?
Okay, Your Honor, I have a few
I'm trying to make
answers.
sure we have two duties, and they're two different legal analysis. And the first one, if you can see it, if the proprietor doesn't have to warn you that, then that duty trial court may not have erred, and that would leave us with a duty to maintain.
Sure, and my response to that is, first of all, there's nothing in the record to suggest, and Ms. Kleiman denies seeing it. Second of all, that wasn't the basis. That was not the basis of Publix's motion for summary judgment.
Okay.
And the trial judge isn't permitted to grant summary judgment on an argument not raised. That may become an issue.
That would be a due process concern, wouldn't it?
Yes, Your Honor. So that was the reason it didn't come up at all. The open and obvious.
Okay. I just saw that I was going through the cases and I said, did I miss something? And obviously now you've told me why I would have missed it, because nobody raised it.
Correct, Your Honor. Nobody raised that. The issues in the trial court were actual notice and failure to warn. The trial judge's ruling was really only based on actual notice. The judge stated that based on the judge's view of the surveillance video, Mr. Hancock did not have actual notice. It's our position that was an error, because that required fact findings in addition to the findings on failure to warn. And I suspect that I am into my rebuttal now. So
yes, you are, but you are doing me the pleasure of answering my question, so I'm not going to charge you into your rebuttal time. It's one of the few perks you have as center chair.
I appreciate that, Your Honor, and I will reserve what time I have left for rebuttal.
Thank you. Okay, we are ready for the Appellee's Counsel, Attorney DeWolf.
Good morning, Your Honor, and may it please the court. I'm Diane DeWolf for the Appellee Publix Supermarkets. Your Honors, the undisputed material facts of this case can be summarized in just 2 or 3 sentences. What we have that is undisputed is a Publix employee out of the corner of his eye saw a little boy vomit. He made a split-second decision. He looked around, he saw that nobody was near it, and he turned around and grabbed a trash can and covered the vomit, in which no one fell. In the 13 seconds that from when he saw the vomit to when he covered it with the trash can, plaintiff fell in vomit that was much further down the aisle. Now, the only disputed issues of fact that I'm hearing counsel say is that whether this vomit was in a trail or whether it was in 2 separate spots. 1, I don't think that's really disputed. 2, it's not material. Because whether there was a trail of vomit in the beginning, whether there was a trail of vomit down the aisle, the undisputed fact is that Mr. Hancock, the Publix employee, didn't see it. He only actually saw the spot where the child vomited, which he covered with a trash can and in which no one fell. So what counsel is actually asking this court to do is say that Publix had actual notice of a spot of vomit no Publix employee ever saw before the plaintiff fell in it. No one told any Publix employee that there was vomit down the aisle. No one told a Publix employee there was a trail of vomit down the aisle. And no one fell in the vomit that the Publix employee actually did see. So really, and plaintiffs have been very, very clear that they're bringing an actual notice case here, but their argument is really a constructive notice, right? So was the vomit there for such a particular amount of time that you should have seen it and told somebody or done something about it? That's really the argument they're making, but they've been very clear that this is an actual notice case. when it's very obvious from the record that no one had any actual notice of the vomit in which the
So,
plaintiff
Mr.
fell.
Wolf, I was curious about that actual notice and duty to maintain and where the duty to warn figured in here. And in looking back, it does seem that while the trial judge didn't rule directly on duty to warn, it's an issue that was argued below and in this court. And the question is, your opponent contends that Hancock, the minute, at the very instant he saw what was transpiring, could and should have just stopped where he was and verbally alerted everyone in the surrounding area that there was vomit on the speedway. What's your response on that?
Well, again, Judge LeBret, what we're looking at here is a Publix employee who only saw the spot where he was, and he covered that spot. So his other option would have been, he didn't know, he testified he didn't know there was vomit anywhere else but this one spot that he saw, okay? So the other option, I guess, is that instead of quickly making a split-second decision to cover it with a trash can, he could have stood there and said, warning, warning, there's vomit here, don't step in it. Okay, we know from
that, from your perspective, requires the stacking of a couple of inferences.
Absolutely. And the rule against stacking inferences is this: if you cannot establish the first inference to the exclusion of any other inference, then you could not make any further inference. So the inference here is that if he had stayed put, if Mr. Hancock had stayed put instead of going and grabbing the trash can, that he would have seen this vomit that was in a trail all the way down the aisle. But you can't establish that to the exclusion of any other inference. One, if you decide you're going to stay there, we've all seen employees in stores doing this before, standing by a spot. You're looking at the spot, right? You're not looking around to warn people of other spots. You're looking at the spot that you're guarding, or you're telling people, step aside, don't step in this spot. You cannot, to the exclusion of any other inference, say that if Mr. Hancock had stayed put, he would have seen all this other vomit that was allegedly down the aisle.
So just to cover what I think is your opponent's position on this, their argument, if I understand correctly, is that the base inference is the boy threw up on the speedway somewhere, maybe many places. Hancock saw the boy throwing up. There's no dispute that Hancock eventually saw the boy throwing up, and that's enough from your opponent's perspective to create a jury issue on causation. Can you speak to that?
Again, Your Honor, Mr. Hancock did not see the boy throwing up down the aisle. Mr. Hancock was not looking at the boy when he came down the aisle. He wasn't looking at the boy when he was cupping his hands. Mr. Hancock's testimony was, I was stocking the shelves. I was putting cheese on the shelves, and out of the corner of my eye, I caught sight of a little boy vomiting. I looked down, I saw a spot, I turned around, I made sure nobody was there. I grabbed a trash can, I put it over the spot. So the fact that he actually saw that spot is really not disputed. He actually saw that spot and he covered it and no one fell. And Mr. Hancock's testimony is that he didn't know someone had thrown up that far down the aisle. Mr. Hazeledge, who was the seafood specialist, also testified that where the plaintiff fell was much further down the aisle from where Mr. Hancock covered the spot with the garbage can.
So I'm sorry to interrupt you. Just one other witness here was Ms. Allgood, who, at least in your opponent's telling of her testimony, she saw a trail of vomit, she saw multiple spots. Is there a conflict in her testimony with Mr. Hancock's testimony sufficient to create a jury issue here on causation?
No. And first of all, Miss Allgood didn't see anything. Miss Allgood saw nothing on the floor. She was the customer service manager and she was paged from the front of the store. By the time she got there, everything had been cleaned up. Miss Allgood didn't see anything on the floor. What she testified to was that someone told her, and she can't remember who, that it was trailed a little bit in the beginning. That was her testimony, but she never personally saw anything. Mr. Hazelet said that it might have been a little trail in the beginning, and Mr. Hancock didn't see it at all. So, and I also think that there's a lot of argument here about the trial court relying on the video, and the trial court didn't rely solely on the video to reach his conclusion here. He had deposition testimony from the plaintiff, who testified that she never saw anything on the floor before
And to that point, I'm glad you brought that up. Your opponent filed Wilson Art a couple of days ago as supplemental authority. Sorry. And I was sort of curious about the timing on that, but also to hear about the differences between how the Wilson Art court viewed the video, or how that video, the role the video played in Wilson Art, versus the role the videos played here, and whether Wilson Art has any bearing on how we address these issues.
Certainly, Your Honor. And I don't think that Wilson Art helps plaintiff's case at all. It's a very different case from this one. First of all, because in Wilson Art, there was dash cam, what an actual dash cam supposedly showed, and eyewitness testimony that directly contradicted what the dash cam allegedly showed, right? So we don't have that. We don't, again, if we're going to argue about whether there was a trail or two separate areas, it doesn't really matter, because that's not material. And, you know, I'm sure there was a trail in the beginning, but it could have been caused by the plaintiff, whatever. But anyway, back to
your position here is, for purposes of Wilson Art and why it isn't controlling, is there you had eyewitness testimony that directly contradicted what the dash cam showed, which in the end was found to be a sufficient triable issue. Here we have the testimony, the only direct testimony that we have is Hancock telling us what he saw, and that's not necessarily inconsistent with what the videos show.
It's not inconsistent at all. It's perfectly consistent with the video. And in Wilson Art, all the Supreme Court really held at the end of the day was that it wasn't going to make an exception for video testimony in summary judgment cases if there was directly, you know, competing evidence that was directly contradictory to the video evidence. We don't have any evidence here that contradicts the video, but moreover, we don't have a trial judge that relied solely on the video. As I was saying, she relied on the plaintiff's testimony, who never saw anything before she fell. And then after she got up, she said, oh, I saw a trail of vomit once I knew what to look for, you know, and again, she fell under the cart, her foot slipped, you know, she could have created the trail of vomit.
And from Publix's perspective, Mr. Hancock said what he said, he saw what he saw, and what he saw was the child vomit right in front of them at his end of the speedway. The videos from all of the angles don't contradict that as much as they just provide context. Is that your position?
That's correct, Your Honor. That's correct. So we have Mr. Hancock exactly saw the one spot. Mr. Hazelnut said that the plaintiff fell much further down the aisle from where Mr. Hancock covered it. And again, Miss Allgood testified that, you know, she never saw it at all, but somebody told her there was some trailing a little bit in the beginning. So from the totality of this testimony, from the depositions, and from the video as well, the trial court.
Let me ask you a question, Mr. Wolf, about the remedy that the plaintiff wants here. They want us to reverse and send it back. And if we do, the next round, I am guessing that Publix would ask us to send it back without prejudice to renew the motion under the new standard after May 1st.
I'm sorry, I missed what you said.
The
summary judgment after May 1st. I'm sorry. Yes, I
correct. The remedy, the plaintiff wants another swing at this. And is there any reason why we wouldn't allow Publix to renew its motion on reversal under the new standard. Talk to me about that, and how does that affect our disposition today? How should we view that?
Well, Your Honor, first, of course, I don't think we have any disputed issues of material fact.
I'm just asking you to assume the
Under this
worst
standard.
case for purposes of analyzing the remedy and whether it's meaningful.
Yes, well, and I think that if after May 1st, if the summary judgment standard, if the federal standard is adopted, that plaintiff will have an even tougher time withstanding a motion for summary judgment. It'll be even more difficult because it's no longer a scintilla of the evidence. It has to be something that could actually make a difference in the case.
And of course, your position here is under the present standard, there's not a triable issue of fact.
No,
because at best, what we have are a series of stacked inferences built on the notion that Mr. Hancock could and should have seen and done a bunch of different things than he did.
right. And again, and I think you're understanding our position here very well. I'm sensing that. I just, the last point I would just like to make is that Mr. Hancock, may have detoured from Publix's internal policies and leaving to get a trash can and cover it up, but that still doesn't imply negligence and causation, because detouring from a business's internal operating procedures does not set the standard of care. And this is the case, the Dominguez case that Judge Casanova brought up. And in that case, that was also a Publix case, I believe. The Publix employee heard a bottle of detergent fall on the floor and he ran over there and he was looking at it. He righted the bottle and he was looking at it, maybe perhaps trying to figure out how to clean it up. And someone came behind him, a customer in the store, and fell in the laundry detergent. And the argument there was he didn't do what he was supposed to do. What he was supposed to do was block off the aisle, immediately block off the aisle. He wasn't supposed to be righting the bottle or looking at trying to figure out how to clean it up. He was supposed to block off the aisle and he didn't do it. And the court said he acted reasonably under the circumstances, that there were just seconds and that they could not impose liability. There was no way to impose causation and liability there. And if anything, our case is even stronger than that, because the plaintiff didn't fall in the spot that Mr. Hancock cleaned up or covered. She fell in a completely different spot. So I don't know if you have any other questions for me. But Your Honors, no reasonable juror under the facts of this case could find negligence, let alone causation. And for those reasons, we ask that you affirm. Thank you.
Thank you, counsel. We can
I want to start my rebuttal. I'm sorry, Your Honor.
I said we can proceed with your rebuttal. Thank you.
Sure. I want to start my rebuttal with the comment that if the vomit was there to be seen, and there's evidence it was in front of Mr. Hancock, then his denial of seeing it merely creates a jury question. There's absolutely nothing in the law that requires a defendant to admit actual notice. It is a question that a jury can decide. And there is conflicting evidence of that. And that comes from all of the deposition testimony and the video. And I want to read what Mr. Hancock.
Well, it's the plaintiff's burden to make at least a prima facie case here to withstand summary judgment that Publix had actual knowledge. Would you agree with that?
I agree with that, Your Honor. Yes, and we have done that. We've done that through the video and the deposition testimony. And I want to read what Mr. Hancock said in two places in his deposition that shows how it is unclear exactly what happened, but there is evidence that he knew about more than just this single spot of vomit. On page 5 of his deposition, which is at record 169, he's asked, do you have an independent recollection of those events? And he says, yes. I was stocking the cheese at the time, and out of the corner of my eye, I saw this woman rushing her son to the restroom, and he was in the process of throwing up. So he saw the woman rushing the child to the restroom in the process of throwing up. There's nowhere there where he says exactly where he saw the woman. So the question is, where did he see the woman? Where did he see the child? What was he aware of? The video shows him looking in that direction at certain times. So it's up to the jury to determine whether he knew where the vomit was, exactly where it was. But there is evidence in this record that entitles the plaintiff to have this case go to a jury for a jury to make that determination, not the trial judge, based on the trial judge's view of the video. And the trial judge did, although the trial judge says there was other evidence, that what he said in the order is telling. He says, in this case, the video shows that Publix supermarkets did not have actual knowledge of the dangerous condition that caused the accident, a small amount of vomit at area 1 where plaintiff fell. Just within that sentence, there are 3 fact findings, and it's clear the trial judge was relying on the video. There's a fact finding that Mr. Hancock did not have actual knowledge, that the vomit was in a small area. There's contrary evidence to that. And that there was an area 1 and an area 2. There's contrary evidence to that. No stacking of inferences is required. That was a question that you had, Judge LaBritte, and I wanted to clarify that. There's direct evidence of each element of this cause of action. There's evidence, we know.
Well, the direct evidence is that Mr. Hancock saw the vomit in spot 2. Everything else is in play as to what he saw before, out of the corner of his eye, the mom was rushing the child past him.
Well, there's that direction. Correct. There's that testimony. That's direct evidence. And that can be interpreted in different ways. The video is direct evidence. The video, a jury could look at the video and determine in which direction he was looking. And again, that's why I say if the vomit's there to be seen, he can't shut his eyes to it figuratively and say, I didn't see it, and absolve Publix of liability.
Well, I'm not sure that helps you a whole lot, given the questions about and Dominguez that Judge Casanova posed to you. That evidence is in this record. Is there a reason why we can't rely on the tipsy coachman, given that Ms. Kleiman was, under this view of it, equally capable of observing the vomit before she slipped in it?
Yes, for exactly the reason that Judge Casanova mentioned, the due process issue. It's very clear, and I'm happy to provide supplemental authority, that a trial judge is not permitted to grant summary judgment on a basis that's not argued. And if a trial judge can't do it, there should be no reason an appellate court can do it for the same due process issues. It is ultimately, at the end of the day, the moving party's initial burden to come forward with the summary judgment arguments. And Publix chose which arguments to make and did not make that argument. So
there are different rules for tipsy coachman than there are, I think, for the trial judge's ruling. We are restrained. I think everything has to appear for tipsy coachman on the face of our record. And I guess the key part is, does everything appear? But I think there's a different analysis for tipsy coachman than merely the trial court's denial because somebody didn't make the proper argument. If we see it's there and it supports the result, I think under tipsy coachman, there's a pathway that we have to follow before we can exercise that doctrine.
Well, I don't necessarily agree, because I think there is a due process requirement that the plaintiff have an opportunity to at least come forward with evidence refuting that. And since it wasn't ever raised, the plaintiff didn't have the opportunity to refute it either in the trial court or in this court. It wasn't raised in the answer brief as well.
If my recollection is correct, there's an opinion, I think, authored by Judge Kelly of this court that talks a little bit to that issue.
I will look for that after this argument, Your Honor. I wanted to just address, I hope I have
It would support your position, by the way.
Oh, thank you, Your Honor. I'm happy to hear that. And that's what I would expect, because there is, due process is important, especially on summary judgment. We're taking this case away from a jury, and the plaintiff should have a right to respond to those arguments. I did want to address the Wilson Art case in 2 respects. First of all, what that case establishes is that a video is a single piece of evidence, and it can be refuted by other evidence. It can also refute other evidence. There is no special summary judgment rule for a video. The trial judge in this court, in this case, seemed to apply a special rule by looking at the video and making interpretations. And then the effect of the change in the summary judgment rule, in this case, it won't make a difference, because while it's the plaintiff's burden ultimately at trial, the plaintiff also met that burden on summary judgment. There are a class of cases where a moving party says, or a responding party simply says, we say there's a dispute, and so there's a dispute, and it's your moving party's burden to disprove our case. That is not what happened here. The plaintiff came forward with affirmative evidence supporting her position. If that evidence were submitted to a jury, it's our position it would be sufficient to get past the directed verdict. So the new standard won't make a difference in this case. The outcome should be the same. This case should go to a jury. It should get past summary judgment, past directed verdict, and go to a jury. Let me see if there's anything else I need to
I
address.
should probably tell you that your time has expired.
Thank you, Your Honor. I'm glad that you told me that. So I'll just conclude by saying it's our position that there are disputed issues of material fact. Summary judgment was inappropriate, and this court should reverse and remand for further proceedings.
Thank you. And if you're looking for a starting point, you would start with Meyer versus Meyer, 25 Southern 3rd, 39, and you'd segue to State Farm Auto at 267 Southern 3rd, 453. Not that I have a brilliant recollection, but I just lectured on that subject. And I have my notes right here on the computer. So I just happen to be fortunate that I can access my computer.
Thank you, Your Honor.
Thank you both. I think that concludes this presentation, and wish you all good health. And I hope we get the chance to see you sometime in a little more personal way.
You as well.
You take care, and we'll go ahead and, well, I think the phrase they told me of Art that we're going to fetch them over from the other side.